Good morning, everyone. Thanks for joining us on this lovely morning for our first business law breakfast of 2023. I was just saying to Andrew, I did the first business law breakfast last year and everyone had masks on, so I'm glad we've come a long way from that. We've got a very hot topic this morning, privacy, which we've got three of our brilliant lawyers talking about today, Summer Al-Tayi and Rick Burkett. We'll take you through various issues associated with privacy, the Privacy Principles, Privacy Act, Health Records Act, and some employee information from Brit as well. Obviously, the topic's very hot at the moment with Optus, the many bank breaches, and the government last week kindly dropped a 300-plus page report about amendments or proposed amendments into the Privacy Act. So we're not really going to touch on that today. Or else you might not get out of here until next Monday. But stay tuned for more information on that. Just a few pieces of housekeeping for me. Toilets are through where the lift wells are. And if we can keep questions till the end today, just because we do have a lot to get through. So anyone online, please use the Q&A function. Oh, the chat line. Thank you, Andrew. To ask the question. So first of all, I'd like to introduce Summer Al-Tayi. She's just recently joined Aitken Partners in our dispute resolution and litigation team. She has 10 years experience in that area and she is going to run you through the Privacy Act and the Privacy Principles. So please welcome Summer.
Thank you, Julie. Thank you, everyone, for coming today. If I do forget to move on to the slides, can you please remind me? As Julie said, we have a lot of information, so we're going to jump right into it. There will be some slides that might be skipped over, but that's just because we're trying to work with the time that we have. So, the Privacy Act 1988 is a Commonwealth law which regulates the handling of personal information about individuals. Most states and territories have equivalent legislation which covers the public sector agencies such as the Privacy and Data Protection Act 2014 here in Victoria. I will be taking you through a brief overview of a number of matters regulated by the Privacy Act and how these matters impact your business. I will also include a brief look at a couple of the Australian privacy principles, which I will refer to as the APPs. What I will stress is that the Privacy Act and the associated APPs are quite extensive, and the Act itself is about 400 pages, so by no means am I going to go through any of it in great detail today. What I hope you will be able to take away from today is the importance of being aware whether the Privacy Act in its current form applies to your business and some of the matters that you will need to be aware of when dealing with a person's personal information. We do have a bit to cover, as I said, so I do apologise if it appears that I'm rushing through some of those things. Okay, so why is it important? A breach of the Privacy Act entitles the Commissioner of Information to apply to the Federal Court or Federal Circuit Court for an order that an entity that is alleged to have contravened a civil penalty provision in the Act pay the Commonwealth a penalty. I can see the sun is in some people's eyes. Could we just maybe take some back down? Sorry. So this is what. Thank you. So the civil penalty provision in the Act have increased from $420,000 for serious or repeated offences to a massive $2.5 million for a person and a staggering $50 million for a body corporate. More importantly, a breach of the Privacy Act could have significant consequences on your business reputation in the wider community. So, what is personal information? As I mentioned, the Privacy Act regulates the handling of a person's personal information. It promotes the protection of the privacy of the individuals, while recognising that this protection should be balanced with the interests of the entities in carrying out their functions or activities. So what is personal information? I mean, this is quite obvious, but the concept of personal information is broad, and in most cases, whether or not information is personal information will be a straightforward question. However, obviously, in some cases, it may not be as clear, and the answer will depend on the context and the circumstances. So, personal information. It's defined under Section 6.1 of the Act and means information or an opinion about an identified individual or an individual who is reasonably identifiable. So, reasonably identifiable, whether the information or opinion is true or not, and whether the information or opinion is recorded in a material form or not. So, noting that no further detailed definition of personal information is provided under the current Section 6.1, information does not have to be explicitly recognised as personal information to constitute personal information under the Act. The types of information that are personal information are unlimited and can vary widely. However, there are common examples of personal information. They include obviously the names, addresses, date of birth, medical records, bank accounts, and even an opinion about a person, which I found to be interesting. There are a number of different types of information, which are explicitly recognised as constituting personal information under the Privacy Act. For example, the following are all types of personal information. You have sensitive information, which includes information or opinion about an individual's racial or ethnic origin, political opinions, religious beliefs, sexual orientation, or criminal record. Information or opinion otherwise meets the definition of personal information. You have obviously health information, credit information, employee record information, tax file number information. I'm going to skip. So, Part 3, Division 2 of the Privacy Act prescribes 13 Australian privacy principles, which I'll just refer to as APPs, and the contents of these are set out in Schedule 1 of the Act. The APPs set out standards, rights, and obligations for handling, holding, use, accessing, and correction of personal information. We will circle back to the actual APPs shortly. In the meantime, let us consider who do the APPs apply to. So, the APPs apply to what is known as an APP entity. Section 15 of the Privacy Act provides that APP entities must comply with the Australian privacy principles and must not do an act or engage in practice that breaches an APP. An act or practice breaches an Australian privacy principle if and only if it is contrary to or inconsistent with that principle. Exceptions include Commonwealth contracts, disclosure to the National Archives, conduct abroad that is required by the applicable law of the foreign country. However, the act or practice can still be breached even if engaged in abroad. So what is an APP entity? An APP entity is defined as an agency or an organisation. The definition of an agency under Section 6 contains a number of subcategories, which include a minister, a department, or a body, tribunal established or appointed for a public purpose or by or under the Commonwealth. The above examples are only a number of the categories listed. However, you will understand the general nature of the entities which are classified as agencies. So they're basically connected with government and associated entities. So organisation is probably more relevant to most of you here today. The term organisation is defined in Section 6C to mean an individual or a body corporate or a partnership or any other unincorporated association or a trust that is not a small business operator. A registered political party, an agency, a state or territory authority, or a prescribed instrumentality of a state or territory. So, what is a small business and what is a small business operator? So, you will note that one of the exclusions from the definition of an organisation is a small business operator. In the current legislation, small business operators are not required to comply with the APPs, but may be required to comply with other sections of the Privacy Act, depending on the personal information that they hold. You will see shortly that the small business operator exemption has been one of the key themes of Privacy Act review report, which was published on the 16th of this month. Now, Julie said we won't touch on it and we won't be going in depth, but if we do have time at the end, I'll just quickly run through some of the things that might be considered for the amendments, and whether the exemptions will apply to small businesses will be one of those considerations. So in the meantime, as the Privacy Act is in its current form, a small business is generally an organisation if its annual turnover in the previous financial year is 3 million or less. There is a test for a new business, and this is based on the turnover being less than 3 million in the current financial year. So if there's any doubt as to whether your entity is required to comply, we suggest to err on the side of caution and seek appropriate advice. So section 6D3 defines small business operator as an individual body, corporate partnership, unincorporated association, or trust that carries on one or more small businesses and does not carry on a business that is not a small business. So based on this definition, small business operators are not required to comply with APPs currently. However, under section 64, the following will not be considered a small business operator. So an individual, body, corporate, partnership, unincorporated association or trust that carries on a business that has had an annual turnover of more than 3 million, as we mentioned, for a financial year that has ended after the later of the following, the time he or she has started to carry on the business, the commencement of this section, or provides a health service, or discloses personal information about another individual to anyone for a benefit, service, or advantage, or if you provide a benefit, service, or advantage to collect personal information about another individual or anyone else. Example, businesses that sell or purchase personal information, or if your entity is a contracted service provider for a Commonwealth, credit reporting body, employee association registered or recognised under the Fair Work, businesses that have opted into the Privacy Act, businesses prescribed by the privacy regulations. Therefore, if your business falls within one of these categories, they're not classified as a small business regardless of a turnover and will be required to comply with APPs. So, moving on to or just by way of an overview of the Australian Privacy Principles, or the APPs. While the APPs are not prescriptive, an APP entity needs to consider how the principles apply to its own situation. The APPs basically deal with the privacy of personal information, including ensuring that APP entities manage personal information in an open and transparent way, the collection of personal information, including unsolicited personal information, how APP entities deal with the personal information, government-related identifiers, including principles about the use and disclosure of personal information and identifiers, the integrity of personal information, including the quality and security of the personal information, and requests for access to and the correction of personal information. Let's go on. As mentioned earlier, there are 13 APPs outlined in Schedule 1 of the Privacy Act, and they are open and transparent management of personal information, anonymity and pseudonymity, collection of personal information, dealing with unsolicited personal information, notification of the collection of personal information, use or disclosure of personal information, direct marketing, cross-border disclosure of personal information, adoption, use or disclosure of government-related identifiers, quality of personal information, security of personal information, access to the personal information, and correction of the same. So, again, due to the time constraints and the breadth of the requirements of the APP, I will only touch on a number of the requirements of the APPs that apply to the entities The matters which I will touch on relate to the requirement to have in place privacy policy, the collection of personal information from individuals, and notifying individuals about the collection of their personal information. So, basically, turning to the privacy policy. In order to satisfy the requirements set out under the first principle, open and transparent management of personal information, APP 1.3 requires that an APP entity must have a clearly expressed up-to-date policy about the management of personal information. There are specific requirements to be included in the policy, such as the information that the privacy policy must contain, a requirement that the entity take reasonable steps to make the privacy policy available and free, a requirement that the entity take reasonable steps to give the privacy policy to an individual in the form that they ask for, so if they don't have a computer, hard copy. Important matters for your privacy policy. So, in developing the appropriate policy, it's important that you think about what form of the policy will take and the specific needs and requirements of your business. We will move on to the employee training. So, the privacy principle 1.2, for example, requires an APP entity to take such steps to implement practices, procedures, and systems to ensure that the entity complies with the APPs, and that will enable the entity to deal with inquiries or complaints from individuals. So it's really important to provide sufficient training to the employees. In terms of the collection of personal information, so APP 3.1 and 3.2 require that an entity must not collect personal information other than sensitive information unless the information is reasonably necessary for or directly related to one or more of the entity's functions. With regard to sensitive information, so an APP entity must not collect sensitive information unless the individual consents, and either APP 3.1 or 3.2, so for agencies and organisations, have been satisfied, or an exemption under subclause 3.4 applies. So 3.4 is basically, it's quite extensive, but for instance, it includes information required or authorised by law or court, tribunal, amongst other things. So, means of collection, APP entities must collect personal information by lawful and fair means, which is pretty self-explanatory. So notification of collection, the APP 5 governs the notification to individuals about the collection of their personal information. So obviously you need to tell the person that you'll be collecting the information. So this is to be done at the time, or if not practicable, as soon as practicable after the collection of the information. And it requires, obviously, to notify the individual that such matters referred to in clause 5.2, which I have a list of, but I won't go through, are reasonable in the circumstances, or otherwise ensures that the individual is aware of such matters, and we can read it if we have time. So, this was, and the slides will be made available to everyone who's joined today. So if we're skipping through anything and you're interested in it, the information will be there, and you can always just reach out. So, the APP also covers, well, given the fact that I've only discussed the APPs which are covered by the Privacy Act, it also specifically regulates the handling of consumer credit reporting information, including credit reporting bodies, credit providers, and certain other third parties, and tax file numbers under the tax file number guidelines. We have prepared some slides for the tax file numbers, or the tax file number rule, which is a rule that the businesses holding an individual's tax file number must comply with. However, given that we don't have much time, we will skip, and again, we can come back to it, or the information will be there, and you can just reach out to us. So, without further ado, I might hand over to Rick now.
Ricky is our next speaker. Most of you will know Ricky doesn't really need introduction, I'll say. He's going to talk to you about notifiable data breaches. Rick also does an extensive amount of work in the health and aged care industry, and he will also touch on the intersection between the Privacy Act and the Health Records Act and collection of health information. So please welcome Rick.
I'm going to move this slightly because I'm not going to use it. As Summit said, these slides are going to be available to everybody. I'm going to do the same thing. I'm going to skip a bit. What we're doing is trying to fit 4 different topics into what could have been an hour each. It's like a 100-metre relay, so apologies. But to just get along the surface is no use to you either. So we'll see how we go. I'll talk fast. So, notifiable data breaches. What Summit talked about is what you can control. How you collect, how you use, how you store, all those things. You control that, and if you don't control it, you get in trouble, and that's really bad. This is when you lose control. Data breaches are becoming more and more common. We're going to mention Optus and Medibank 400 times today, but nobody doesn't know. Medibank, 9.7 million people's data was accessed. And so you can kind of understand why the government has also, just in December, said we're doing some changes immediately, which is what governments do when people yell. But as Summer said, there's also a report that dropped. And it's great when you're preparing one of these seminars and they drop a 300-page report out of the blue and say, oh, by the way, these are some changes we're considering. But again, that'll be a whole other topic. Part 3 of the Privacy Act deals with the notifiable data breach scheme. Came into effect in February 2018. And what it requires really is if there is an eligible data breach, and we'll talk about what that is. It's not everything. It's not, oh, somebody hacked us, therefore we've got to jump into this. There's a few things that have to apply before you're stuck with that. But if you do have an eligible data breach that occurs, you have to contact the Information Commissioner, that's the Commonwealth or Australian Information Commissioner, and give them information about it. And you've got to let the people affected know about it. And again, Optus, Medibank. Anybody who was affected would know that you should have received information. Some questions about the timing of all of that, but I'm sure the investigations that are underway are going to give us answers. But they're great examples. So, if you fail to comply with the eligible data breach scheme, you say, you know what, this is bad PR, let's just put it under the blanket. $50 million is your potential penalty. And if you deliberately fail to comply rather than inadvertently, I reckon you're going to cop it as serious. So, what the Act says is if there is an interference with privacy, and it is automatically an interference with privacy to fail to comply with this scheme, and it's serious, and it'll be serious if you decided not to comply with the scheme, in my view. Okay, some circumstances maybe not. You can have up to $50 million if you're a corporate entity, $2.5 million if you're an individual. And they jumped from these figures before Optus and Medibank, as some said. Thanks Optus, thanks Medibank. The changes in December also in this area brought in new powers for the Commissioner to investigate. So get information from you if there's been an incident, but also to come and look at whether you're ready for an incident. Which is something new, and it's all about preemptive stuff. There's not a lot of guidance at the moment about what they do if they find that you're not, but I'd imagine they'd be watching you even more closely if they come and investigate you, find you haven't got anything in place. So now more than ever, privacy is not just a buzzword. Everybody's talking about it. You're all here for a reason. It's an area of real risk because forget about the $50 million. Your reputation's trashed if you don't comply. Bad enough if there's a data breach. If you are then accused of then hiding it, putting it under the carpet, that's really bad stuff. Obviously, that's reputational damage that you've got to factor into all of this as well. What is it? What is an eligible data breach? It's unauthorised access to, disclosure of, or loss of personal information. So that's the first key. Did the data hack or did the loss of information involve personal information? I don't want to go over it in too much detail because Summer already has, but it's information about an identifiable individual. And so my phone number on its own is probably not personal information, sometimes depending on context. A photo of me with nothing else may not be. If I don't have the name tag on and I'm just a random, if I'm walking down the street and I'm in the background of a photo, I don't think that photo getting out is going to be the loss of my personal information. But if it's my name, address, date of birth, credit card number, blah, 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 obviously it moves into that. So it's an assessment of whether what was lost is personal information is kind of your first step. So unauthorised access or disclosure of personal information. So it's a data breach occurs when there's actual access or disclosure. You know you've been hacked. Someone's got in there. You know it's happened because you've seen consequences of it, or the emails you're getting suggest that, okay, that's the oh shit moment is often referred to as, or disclosure. So that can be one of your employees is actually giving it out, or they've accessed it for the wrong reasons. And we've heard about investigations within the police force of going looking up where your ex-girlfriend is. And then there's information lost, and the accesses or disclosures are likely to occur. You leave your mobile phone packed with client information on a train, or your laptop, right? I've just lost the data. And the question then is, well, is there likely to be access and disclosure? We'll talk about that a tiny bit more in a minute. There's also, though, that a reasonable person has to conclude the access or disclosure or loss would be likely to result in serious harm. So is the data that's been given away going to be a problem? Is also a limb. Now, don't be too generous in your assessment of this. But again, my name and phone number, right, I might get a couple of calls. Is that going to cause me serious harm? My name and credit card details? Hell yeah. All right. My name and, my medical records, quite possibly. So there's an assessment of whether or not it's going to cause serious harm. So it's not, again, we got hacked, shit, we've got to run off to, sorry, that's my second. Well, let's see how far we can get into the scale of swear words. But you don't have to run off to the commissioner simply because you got hacked. Look at what it was and then look at what's the consequence going to be. I'm not encouraging you to be, though, conservative about it, but it ain't just automatic. So we've talked about types of unauthorised disclosure will be being hacked or people misusing it, or even disclosing it to the wrong person. And it's that that email that says, I don't think this was meant for me. That in certain circumstances could come under this if there was enough information about it. Lost, we talked about that. Got to be result in serious harm. And the reasonable person is viewed from the point of view of the people that have lost the data, not necessarily the individual. The individual might be hysterical. They might form the view that my phone number, giving that away is, going to cause all sorts of trouble, but there's a reasonableness test. But again, not encouraging you to be convenient about the way you'd assess that. These are the types of harm that you might look at with serious harm: identity theft, significant financial loss, threats to physical safety, and that, again, there was some stuff in the news yesterday about hospitals sharing information and there not being quite the same security around it, and individuals being worried that ex-partners and so forth might be able to access it through the nurse who's their mother who works at the hospital, that sort of thing. Other examples. Serious harm is not strictly defined though, so you've kind of got to apply your own, although the Commissioner has put out a number of guidances about what they think would constitute it. And these are the things you need to assess as well. What kind of information has gone out there? As I said, it's just a phone number, probably, quite possibly not a problem. The sensitivity of the information, similarly, is it my medical records and my employment history and so forth. Were there security measures in place and can they be overcome? Encryption. If you've got data and it's encrypted with encryption technology that's from last year, not 1982, there's a pretty good chance that you may be able to say, look, this data's been hacked, but it's just a number of dashes and dots. There would be very few people in the world who could crack it. And so that will be relevant. But you do have to assess how well encrypted is it. That's sort of repeating what I just said. The volume may be relevant. If two people's information is lost, you can be very specific. Who's that individual? What was lost? What's the harm? But 9.7 million people, fair chance that there might be one amongst them who's going to struggle because of it. And there's a lot of resources. AOIC have got a really good website in terms of, again, what they think about it. Sometimes that's, again, a more generous view from their perspective, but if you're interested, there's lots of materials there. Okay, an eligible data breach is not an eligible data breach if the loss occurs and you take action before there is unauthorised access or disclosure as a result. It's not if there's unauthorised access or disclosure, but you take action before there's any harm to stop that harm. I'm going to come back to these, so I'll skip them. I'll go quickly first. If there's a loss of data and you take action after there's been unauthorised access, but that action will avert the serious harm, you don't have to report. It's not an eligible data breach. Okay? But if the action that you've taken won't cover everybody, 9.7 million people, then for those that you haven't protected, you've still got the obligations. So, examples. So you accidentally send personal information to an email recipient. It's a file attached. You know them well, and you've got good reason to believe they're trustworthy. You get on the phone and you say, I just sent you an email. They say, yeah, I got it. Bloody hell. You say, listen, can you absolutely promise me you'll delete it? Yep. Would you send me an email confirming that you've deleted it? Yep. That person is not a person who trades in data. That would help. But, you know, for me, for example, if it was another lawyer, if I had their undertaking, I would, in most cases, trust that. So, you know, this won't apply to people who you can't have faith in because you don't know them or whatever. But, you know, that's an example of where you might have averted that risk because you're able to lock it down. Okay, so it ceases, if you like, to be an eligible data breach. You leave your phone on public transport, it's full of contacts, right? But you've got the capacity to scrub it remotely. And about, you know, within a few minutes of realising you left it on the train, you scrub it. Okay? You've lost the data, technically, but what you've done is taken action that's likely to avert the serious harm. So the one big suggestion, though, with these things is document all the remedial actions. This is exactly what I did. Have a file note or something of it, evidence of it, or if there's another person involved, a confirmation from them that they've done what they should. But if you take really proper good action, you may have a data breach that you're able to avert having to go through the other stages for. What if there might have been a breach, but you don't know if there's been a breach? If you suspect a breach, but you don't believe it's a breach, and these are the terms used in the Act, but you think something's happened, but you're not sure, you've currently got a 30-day period during which you're required to assess it, but during which you're excused if you haven't reported it, provided that there's, you know, the grounds are reasonable you're relying on. I reckon something's happened here. Our data's showing that there's been somebody entered, but I can't find any evidence of them actually getting data. You don't need to report yet. You start your investigation. The current recommendations in the new report is to drop that down to 3 days, not 30. And I think that's because of some of the delays, particularly where people go, oh, I wasn't sure. But if you're aware that there are reasonable grounds to believe that it's happened, and it's not that you've got absolute proof, but you know it probably has, then you have to firstly report to the Information Commissioner. You need to provide contact details, description of the data breach that's occurred, the kind of information that's involved, and what you're going to do about it. And you need to lodge that with the Commissioner. Then you've got to tell everybody involved. You either give them a copy of what you gave to the Commissioner, or if you can't do that, you take other reasonable steps to notify the content to them, and that might be media, it might be just going out to your entire customer base, even though you think it might be limited, or only if you can't do those things, which are very direct, trying to get to the individuals involved, then put it on your website and make public statements about it so the maximum number of people find out. You've got to tell the people involved that this has happened so that they can protect themselves. That's the bottom line. Two things about that. One is compliance. You break the law if you don't. The second thing is if you tell them and they protect themselves, the chances of them suffering harm, which is going to come back on you, is reduced. It's just a really sensible, practical thing to do as well as a legal requirement. Understand that if you send information overseas to a recipient, and there are other laws about doing that, restrict you, but if you do that and they get hacked, you are responsible. An Australian entity that sends it overseas is responsible for the loss of the information overseas. Think about that when you're entering into contracts with cloud providers. Where is their data centre? Is it in Australia? It's a pretty big question when you come to these sorts of things. Don't worry about that. It's exciting, but you can read it later. Between the stats, between 1 April 2018, so shortly after it commenced, that's when they started publishing the proper stats. There's been 4,109 data breaches or notifiable data breaches that were notified. I don't know what the number might be of not notified. I suspect notifications are on the up though now that we've seen some of the recent issues. But 67% of them only involved 100 people or less, the data of 100 people or less. So the vast majority of them have been fairly small and you'd hope, capable of containment. The health sector, which I'm going to have a quick touch on in a minute, have topped the list every single report. And I've read every one of them, every single one, health sector, right there. 16.5% of the total reports are in health. The majority, about 2/3, have involved malicious attacks, so that's hackers. So most, 2/3, but a third, and forgive my having more than 3/3, but about 1/3 is due to human error, which is pretty high. So making sure your people know what they're doing and the people who you work with know what they're doing, that just shows how important it is. A third are human error and 4 to 5% are actual system failure. So it's not that common that it's the computer that's to blame, right? I know we like to turn it off and turn it back on, but it's really going to be that.